I'll give you a little bit of background on myself. My name's Brock Rowe. I'm a member of the Big Stone Cree First Nation, which is located in central Alberta. I grew up I was born and raised in Fort St. John, British Columbia, which is about an 8-hour drive up the highway, just past Grand Prairie. I am an alumni of the U of A. I went to the University of Alberta in 2000 through the TIP program and graduated with honors from Native Studies. And I also graduated from the law school in 2009. I worked at a national full-service law firm and summered there, articled there, worked as an associate there. And then the First Nations practice group convinced me to come join them at McPherson Leslie in Tyerman almost 2 years ago. So that means I've only been called as a lawyer for about 3 years, so I don't want to hold myself out as any type of expert or the person with the go-to knowledge on everything about this, because trust me, the law with respect to water is complicated enough. Law with respect to First Nations in Alberta or Canada is complicated, and it's even more complicated when you combine the two together, because you have multiple jurisdictions telling each other what they think their respective law is and jurisdiction over water, right? Which can be located in the surface, river, lake, or below the ground, right? Or in people. So, my presentation is kind of in the context of Canada and Alberta. So I'll talk briefly about what's going on in Alberta with respect to First Nations here, as well as the relationship with Canada and the proposed, Bill S8, right? That's been on everybody's mind. And I just kind of want to get an idea of who's in the room, because it's hard to tell if we don't have big name tags and we haven't been in meetings with each other continuously. So just maybe acknowledge yourselves, wave your hand when I name your group, right? So lawyers, is there another lawyer in the room? Right on, one more. How about academics, like profs, grad students? Good, right on. That's nice to see. And how about government of Alberta? We're consulting, all right. Federal government, Canada. Nobody here from the federal government. Okay, and then just the public. Like not including the other group. So just people who just saw the notice and said, let's come out to this thing. All right, good. So kind of a good cross-section of people. And I'm encouraged to see the writers that I know, Kiwi Martin and her partner. Where's Naomi? She was here earlier. I don't know, Naomi McElrath too. She was in Native Studies as well when I was there, so I miss my schooling days at Native Studies. Anyways, water rights. Oh, this one. Okay. So what water rights are First Nations interested in, or are they claiming, right? This can be grouped very broadly. They kind of intersect, right? But more or less, you can narrow it down into a few different categories. So the right to use on-reserve surface water and groundwater resources to meet the water needs of the community, right, of the First Nation on the reserve. And for those of you who don't understand, the concept of on-reserve literally means different jurisdiction than the province, right? So the courts and the state understand on reserve to mean federal jurisdiction. Everywhere else, pretty much, except for national parks in Alberta, is provincial jurisdiction. Let's put it that way, right? So the right to use on reserve surface water and groundwater resources to meet the needs of the community, right? Housing, fisheries, water management, agriculture, and commercial development. Because these are participating people in the economy, they have their own plans and priorities and what they do as well. The right to safe water supply on reserve. The right to govern local water resources on the reserve. The right to quantity and quality of water resources off reserve, right? So now we're going into the provincial sphere of things. To sustain the constitutionally protected treaty making, or treaty hunting, fishing, and trapping rights, right? So where I'm going with that is First Nations are concerned not only about the water on the reserve and where they live, if they live on the reserve, but also off the reserve, when they go to exercise their rights pursuant to a treaty, be that hunting, trapping, or fishing, and there's other treaty rights too, mind you, okay? Incidental rights, they call them, in support of those things. Camping near a lake, river, when you're going hunting, right? Access to the fresh water that's in that lake or the river, drink yourself, prepare your food. Those sources need to be protected as well, okay? So in the jurisdiction hat world, there's a federal jurisdiction hat and the provincial jurisdiction hat that's being engaged there. And the right to be meaningfully consulted about key water management decisions that potentially impact those rights to on reserve and off reserve that I just talked about. There's a number of legal foundations, we'll call it, for First Nation water rights that have been argued or that are being argued. The first one that a lot of people point to is the honor of the crown, right? Because the crown, which is a hat that the federal and the provincial governments wear, you can think of it that way as an analogy. The honor of the crown is what is referred to by all First Nations in all its dealings with the crown, right? It's a standard that the crown's held to, and they can't be seen to be walking away from that standard. There's a lot more case law on what that means. I'm not going to get into it, but I just understand it's a very high standard that the crown has to meet. One is an old case from 1910 called Burrard Power. Had to do with the transfer, well, when BC entered Confederation in 1871, the BC government, the local provincial government you want to call it, actually didn't pass an order in council effectively transferring lands back to the federal crown under that agreement until 1938, right? So the jurisdiction over water within the railway belt that kind of tied the two together wasn't really settled, and this case spoke on that. And anyways, the important point to take away from this case is that in order to fulfill the object or purpose of the conveyance of land from the crown, the conveyance must include such water rights as would allow that object or purpose to be met, right? So when the provincial crown transferred land to the federal crown as part of its terms of union, it transferred those lands with the right to the water attached to it, okay? So that's an important point. And this old decision, that came down from the Supreme Court of Canada, was applied recently in a case out of BC called Halalt, or Halalt First Nation. And that had to do with respect to water that was located in an aquifer and then an effect of the pumping of the water from the aquifer on the nearby Chemainus River. And we intervened in that at the BC Court of Appeal for our clients. Mainly with respect to what we wanted the court to say on Burrard Power. So when the reserve was created, essentially, it was created with the rights to the water underneath the land, and we would argue on top of the land as well. Okay, that's the point to take away from that. Necessarily incidental rights, right? So a treaty right to hunt. You can go out with a rifle, shoot a moose, dress it up, take the hide and whatnot back home, eat the meat. That's a treaty right, that's pretty clear. But you might need a quad to get out to the land. You might need to start a fire if you want to smoke the hide. We would argue that those are incidental rights to treaty, and those are protected by the Constitution. The example that everybody uses is this case where somebody built a cabin in a provincial park in Saskatchewan, where they would go camp and then hunt from that location. So it was actually upheld to be an incidental right to a treaty right, and it was protected, and within a provincial park, which was even a better fact. Another possible legal foundation for First Nation water rights is the granting of reserve lands, right? So at the time that reserve lands were created, after treaty was signed, it's hard to imagine that when the Crown was surveying these lands and setting them apart for First Nations pursuant to treaty, that they didn't also mean to include the right to the water underneath and on the surface of the lands to sustain the people that were going to be living there, right? You're going to have a large population that was largely restricted to the reserve because of the Indian pass system, right? and without any water, like it just doesn't make sense, right? So in granting those reserve lands, there's an understanding that there's an intention to also pass on the rights to the water, which is similar to the reasoning in the Burrard Power case, right? So this includes the groundwater and the riparian rights, which is a separate body of law, which is actually quite ancient as well. And it was quite common, to be honest, in surveying of reserve land when it was being set apart for the First Nations, that the reserve boundaries actually extended beyond shorelines and out into lakes and out into rivers. And out at the Montana Band, and like out at Hobbema in the Battle River, where the old Montana Band and they had a small plot on the other side of the river, Sampson's Reserve. No, Montana was a small plot and Sampson's was here. The reserve boundary actually meets in the middle of the Battle River, right? It doesn't meet on the shoreline, right? So there you can see that type of intention that I'm talking about. There's other reserves up in the Lakes District around Lac La Biche that actually had subsequent survey in the 1930s where lakes were included, full lakes, small inland lakes, were included in reserves and extended out into the lake to support, a fishing station and a source for water to drink, to use for your purposes of living, right? I keep grabbing the wrong mouse. There were two cases that really kind of set out the framework for understanding Aboriginal rights, at least in respect of how the courts understand them in the state. So in Vanderpeet, which is big Aboriginal rights case, the Chief Justice makes this comment in the various paragraphs quoted here. The right to use the land and waters was included in Aboriginal title, right? And that it could only be deprived on terms that would ensure a replacement for the livelihood, right? Not just the right to go and drink water, but it's a different concept, the right to livelihood, that their lands, forests, and streams provided. And this is in the Aboriginal title context, mind you. In two other cases, Delgamuuk was subsequent, Garin was previous, but these were both cited in that Halalt case that we intervened in. Delgamuuk and Garin suggest that an Indian title in reserve lands is analogous to Aboriginal title, right? So it's tying that concept of the Aboriginal title remarks that the Chief Justice made into title into the reserve lands, right? And the right to exclusive use and occupation of those lands on reserve. So again, here's some cases that talked about water. The Halalt case that I said. The judge, this was a very long judgment to read. I can't remember how many pages. It was about 300 pages. It's because the facts were huge. The process that more or less resulted in the fight between the Halalt First Nation and the municipality beside it took a long time, and there's multiple meetings, so a large portion of the judgment is on the facts. And then these big issues of First Nation rights and jurisdiction and water rights, right, coming together again to be more complex. So the judge had to grapple with all this. Anyways, she made a comment in there that First Nations basically have a strong case to groundwater on reserve lands, and provincial law cannot expropriate that interest or right. And she applied the reasoning in that Burrard Power case, okay? She claimed this close to actually declaring it, but just not right there. There's another case called Claxton in BC. The right of access to water is necessarily incidental to the treaty fishing rights, okay? And then there's the Tsutina and Sampson case where treaty water rights were challenging, but they weren't a dubious or peripheral claim as the Crown would like to frame them. And they were of sufficient merit to trigger the duty to consult. So to trigger the duty to consult means you have to have a potential impact to your treaty or Aboriginal right, okay? Another case called Pasco considered whether riparian rights arise from reserve lands, and it was determined then it was a serious issue to be tried, okay? And then there was a Pagan case, and the motion to strike a treaty water case by the Crown was denied. Next, oh yeah, and there's the Ballantyne Cree Nation versus Saskatchewan, which is interesting, and I go into the record and I try to peek in and try to find out what's going on with this every now and then, because it's still ongoing. The statement of defense that was filed by the Crown, Saskatchewan, actually denies treaty water rights, but admits the First Nations riparian rights arising from the reserve lands, which the Crown directly next door would not agree with that at all. So it's very interesting to see what Saskatchewan is saying with respect to First Nations reserve riparian rights. Also, in addition to other multiple people that are doing a lot of work on this, some of the work that we follow and know about is Graham Statt. He works in Aboriginal relations at the GOA, our Government of Alberta. He did his master's thesis on, I think it was a Treaty 8 right to water. I wrote it down. Yeah, that's right. And then Professor Richard Bartlett, who was actually in Alberta, I think in the 80s, and then left and returned to Australia. He wrote this kind of neat little book. It's just a little white, skinny little book that's coil bound on the treaty or Aboriginal right to water. And to be honest, it was fairly progressive for its time because I don't think too many people were considering that issue with respect to state law at that time. And so that's actually not a bad source to go look. And then Professor Nigel Banks at U of C has a blog that he comments on all the time. And some of it's industry favorite, I think, but he raises issues that are of importance and narrows down the issues really well. So that's a good one to follow. And then Monique Ross is also works with him down in Calgary too. The end point of all this too, discussing the cases, is that there is no definitive case that determines what First Nations water rights are in Canada. Okay, we haven't had that yet. We haven't got there yet. Who knows if and when? And somebody else commented earlier on the political will. I think that's going to largely determine if we're going to see an answer in the courts or an answer through leadership. Next. Oh, the previous. Okay, safe water supply, right? So Bill S8, concepts about that. So federal government, right? Because now we're on reserve. We're talking about federal jurisdiction. The federal government is concerned about water rights, right? And so are First Nations. No, I'm being facetious here. So First Nations are also concerned about water rights. So they said, well, let's sort this out, right? And this is a very, I'm being very sarcastic here. They're not. And they more or less agreed, though, to have an independent body go out and do an assessment on the state of the infrastructure of, water infrastructure on reserve, okay, across Canada. It was a huge undertaking. A company called Neon Burnside, which is an engineering firm, actually conducted this assessment and then presented a report, a very detailed report. And so these are some parts of it. And the amount is staggering, okay? $4.7 billion in funding is required over 10 years just to bring First Nations water systems up to the standards that are enjoyed by people that live off reserve, okay? It's huge. That's not a small amount by any means. Alberta is no exception. $162 million is needed to bring systems up to standards that are considered safe by the federal government. Okay, so that's the federal government standards. That's not the provincial government standards. Only 64% of the systems in Alberta, 64% of systems in Alberta do not have qualified operators running these systems. This is data that was produced in a report 2 years ago. So who knows what the state is now. I don't know if anybody's here from TSAG that can comment on how many, but anyways. 82 systems were risk inspected in Alberta. Of those 82, 21 are high risk. So a quarter, just over a quarter, are high risk, meaning they have inadequate water supplies. And that's absolutely just not acceptable. No, that's just delivery of water on reserve, right? So like going into a house and turning on the tap, okay? 48 are medium risk. Okay, so that's just one step away from high risk. That doesn't mean it's okay to be medium. That's still really bad because it's not up to the standard that's enjoyed by everyone else in Canada. 13 were considered low risk, and 11 of those 13 are operated by municipalities, right? So of the 82 in Alberta, I think the math is wrong, sorry on that, it should only read 2. Only 2 First Nation systems were operating within safe parameters, you can say. There is no binding commitment by Canada to make up for the shortfall in the funds that are needed to bring that water infrastructure to a state where every other Canadian enjoys. Okay. Yeah, no. Yeah, there's such thing as bottled water, and everybody's trucking in bottled water, but who's going to be paying for it, right? When the right to that water already exists, and they should already be having it delivered on reserve, okay? So there's no binding commitment by Canada to funding this. Canada has not responded adequately at all to this report, to the report by Negon Burnside, despite it being raised all the time by First Nations in Senate committees and at the House committees, okay? Canada has restated numerous times, or actually they've kind of regurgitated the same press release for the past 2 years saying that they've committed $230 million. That's a drop in the bucket compared to the $4.7 billion that Negon Burnside identified. And that doesn't go anywhere, trust me, because that gets spent really fast. Alberta. Secure water supply, okay? Markets versus rights to use water. In 2006, Alberta introduced the first water market in Canada, in Treaty 7 territory. In 2006, at the same time, Alberta restricted new licenses from being created in the southern portion of the province, okay? So no new licenses were going to be issued from the Crown. Alberta made it possible for the authorized sale and purchase of existing licenses, okay? And I think I just need to comment on, in Alberta, what we have is a system of first in time, first in right principle. So when Alberta, or the West, was being settled, the Dominion government at the time said, well, let's encourage settlement. Instead of having just the riparian rights regime, which is an old, kind of like English common law way of governing water uses. It meant if you live beside a river, you could use the water from it for your needs and for your cows that you might have had or your whatever farm that you were running. And as long as you took so much and you let enough go by for your neighbors down the road, right? So that's more or less the concept of this riparian rights. So the Dominion government back in the good old day when they were settling the West said, well, that's fine and dandy, but let's do something else that will encourage settlement, encourage farming, which was the economy, the big economy at the time, and agriculture. So they brought in the Northwest Irrigation Act, which had this concept of first in time, first is right. So when you applied as a settler to land, you would apply for this license to water, which your license would give you so much to use per year, let's call it that. And if somebody came and applied for the same amount of water the year later and received a license, their priority is second to yours. So let's say all the water in the river is drying up and there's only enough for one of you. That second priority gets bumped off. First priority gets the water, okay? That's the concept of first in time, first in right, very simply put. So in Alberta, just like what Canada did, it has this first in time, first in right principle. And there are a lot of license holders in Alberta. In fact, the majority of the water in Alberta that's held by licenses were created before this water market was introduced. Nobody paid for these water licenses. These weren't something that you went to the government and said, here's my $1,000, give me 1,000 acre feet per year of water, okay? So it's important to understand that. So what Alberta is saying effectively is that it has jurisdiction to regulate the water on the reserve, remember, in the federal jurisdiction. And it's going to have the jurisdiction to manage how much water each First Nation takes. Okay? That's Alberta's position. Of course, First Nations are saying, no, that's crazy. Alberta says, well, hang on, maybe we can do something here. We've got this thing called the Crown Reservation where, I can't remember if it was the late 90s or early 2000, Alberta put in this Crown Reservation. So a certain amount of water was held back, and First Nations would be entitled to the water in that Crown Reservation, okay? That Crown Reservation has a priority of like the year 1998 or 2000, whatever it is. All of those other priorities still have priority over the First Nations. Who, mind you, First Nations have been here since time immemorial, and they have, as far as I'm concerned, way more senior rights than any other rights holders that are already existing on the Alberta market, right? Yeah. So, yeah, I agree. So just hang on, let me finish. So the Alberta position, again, is no First Nation water rights or jurisdiction over water on reserve lands. There's little or no political will to work with First Nations to find any solutions, okay? There are these water tables that are set up, but they're not effective, in my opinion. And there's no political traction to take everything that I just said previously and negotiate something that would work for everybody or work better for First Nations, because the current state or the status quo is unacceptable with respect to the safe drinking water and the impact to treaty rights off reserve. Okay. So in 2006, this new water market was introduced in southern Alberta. And it basically affected the Treaty 7 First Nations down there, right? The next new market is proposed for Treaty 6 territory, okay? And that's in the process now. Oh. Yeah. The Ministers' Advisor Group, which was this committee, well, it wasn't a committee, it was a group of people, recommended this extension of markets throughout Alberta, right? So not just in the South Saskatchewan River Basin and whatnot. They wanted less regulation of water markets. But in their work, they did not address First Nation issues, or at least it wasn't published in the report to satisfaction of First Nations. And Professor David Percy, who was formerly the dean of the law school when I was there, sat on this committee. I think he chaired it, and wrote extensively, I'm sure, about it internal, but we don't really know too much what he or the group was saying with respect to First Nations. So it would be nice if Professor Percy actually starts publishing on this, but we wait for that. The day is yet to come. So the regulation under the Water Act of Alberta sets aside this unallocated water in basins that are already over-allocated, right? So what that means is that, remember when I said there's this concept of first in time, first is right, where you have all of these license holders stacked up over the course of time with their priorities, and each license, they're entitled to take so much water, okay? Each license holder actually doesn't use all of the water that is allocated. It might only use half, a quarter, 3/4, whatnot. A large portion of the water in southern Alberta is actually taken up by the irrigation districts, okay? These were entities that were created to hold water and issue it, to farmers, mainly for farming, okay, agricultural purposes. Again, these irrigation districts did not pay for these licenses, but they were allocated huge amounts of water in southern Alberta.
That's absolutely disgusting. It is.
And they have a priority that goes a long way back. And I haven't looked at these notes in a while, so I forget when it is, but it's a long time ago, okay? So,
how can you have priority when all these laws you're talking about are domestic laws or inside of Canada? We're not domestic.
Oh, I know. And that's what I'm getting to in the stuff that I was talking about before with respect to First Nations jurisdiction over water, okay? So this regulation under the Water Act sets aside unallocated water that these license holders are using in basins that are already over-allocated. So there's only so much water, but the government issued licenses, hoping that nobody's going to use all their water, okay? So the Crown Reservation sets rules for First Nations water licenses, permitted uses on reserve lands, and a priority, which is the lowest priority in its basin under the first in time, first in right rule. And the way I see this, as a lawyer, this is a direct assertion of provincial, decision-making power over a federal jurisdiction. Okay. This is implemented by something called water supply agreements, which requires an effective surrender of treaty, Aboriginal, and common law water rights, as well as claims to jurisdiction on water over reserve by the First Nations. Exactly.
That's crazy.
Okay. So the concept of the NRTA extinguishing all of these rights and being transferred to Alberta, and I could see Najib Banks actually saying yes, that we agree with that because that's actually what industry in Alberta wants. We say no.
Alberta doesn't own the water.
I know, and that's what we say. So under this, unallocation, or sorry, this overallocation problem, and those rights and priorities that First Nations will get on this Crown Reservation, in the Treaty 7 water market, what that means is First Nations will get water 6 of every 69 years in a low water area or time. And the Treaty 6 water market, First Nations will get water 1 of every 3 years, okay? First Nations are asked to rely also on voluntary sharing under the Water Act in times when water is low. So before the water market was actually introduced, remember these irrigation districts and people who had licenses did not actually have to pay for these licenses. So when times were low, maybe things were a bit more friendly between them and said, well, hey, we don't need to use as much water as we have been. Let's pull back a bit, you'll pull back a bit so we can all get water. Under the treaty, under the water market, under the water market, the unallocated amounts can be transferred by an existing license holder with a prior priority to another person without selling the land, right? So basically, if I own the land and I've got a huge amount of water allocated to me under a license, I'm not using it all, I can sell that portion that I'm not using to someone else, okay? And it's big money. Oh, sorry. Here's a slide from the GOA on the Crown Reservation. Minister may, by order in council, reserve water that is not currently allocated, right? What I just spoke about, under a license or registration. The reservation would specify the use for whom and for what period of time. Through a Crown Reservation, water for the nations can be secured quickly and allows for flexibility going forward for each nation. Oh, great. Con, Alberta uses a first in time, first in right priority. Under this system, the Crown Reservation would have junior standing, with a priority date being the date the Crown Reservation is established, right, which is low priority. Only one Crown Reservation would likely be established and applied to all 4 nations in southern Alberta. Under a new junior license. A junior license is a new license that each nation would apply directly to Alberta Environment for, independently of one another. The volume of water required needs to be specified, and the license would be subject to the matters and factors specified in the plan and the Water Act. It allows each nation to pursue their water needs independently. Alberta uses a first in time, first in right priority system. Under this system, this new license would have junior standing, with a priority date being the date application is deemed complete, i.e. a really junior license, again. We estimate, and this says it right in Alberta's PowerPoint, we estimate that a new junior license would receive their water 1 out of every 3 years, depending on flow in the river. Thanks, Alberta. So here's a clause from an agreement that Alberta wants First Nations to sign. During the term of this agreement, First Nations shall not commence any proceedings against Alberta, seeking a remedy in relation to treaty or other rights to water, priority rights to water, based on a claim of treaty or other rights to water, application of the Water Act on First Nation lands, or the quantity, use, management, and ownership of water. This agreement may be terminated at any time upon the mutual agreement of the First Nation Alberta. So what that clause effectively does is gives a veto to either side. So I mean, you wouldn't get that from Alberta if you wanted to, because Alberta could just withhold, say, well, we don't agree. So.
And that's so wrong.
Yeah, I agree. So this water market concept, who's next? BC. policy proposal on British Columbia's new Water Sustainability Act was released December 2010. It recommends introduction of tradable permits, right? And that sounds familiar because it's like the transfer of the allocations under existing licenses in Alberta. Mentions only hunting and fishing. No mention of unresolved issue of First Nation Aboriginal tidal water rights, on reserve water rights or otherwise. And you have to understand in BC, there's a large portion of BC that is, they'll call it unceded, which is not subject to treaty. There's no treaties in it, right? So the idea is that the First Nations still have Aboriginal title, and that's being fought through the courts and being declared by many First Nations in Alberta today, or in BC today. So they're going so far as to say that, or they haven't mentioned anything about claimed Aboriginal title water rights. And you can appreciate that with a coastal First Nation base too, that's pretty important to the First Nations that are along the coast. BC claims to have spent much of 2010 engaging with First Nations on this Water Act modernization. And if you look at the report, there was 3 one-day sessions, 71 attendees in total, 16 submissions.
Did the people that attended the know the consultation meeting?
Oh, I don't know. I didn't attend, and I doubt it was framed in a way that they would think it was. First Nations say this was not meaningful consultation, and that the province cannot regulate groundwater or surface water on reserve lands, and must accommodate water aspects of Aboriginal title. So none of this input made it into the policy proposal. So BC and Alberta vigorously oppose First Nation water rights, right? So in Pekani, Tsuut'ina, Halalt First Nation, the Crown was there arguing against. Neither government has tabled solutions or attempted to engage in processes to explore the security of water, management or safety of water. What will it cost if water markets do end up applying to First Nations, right? Because remember, in Alberta, you're going to have this water market entity transferring unallocated portions of water to other people, right, for their uses. In southern Alberta, company paid $15 million for a 2.4 million cubic meter license. This is enough for the annual supply of a shopping center, or about 20 homes, right? That's $15 million. How many homes are there on every First Nation, right, that need water, safe water, and secure water supply? The cost implications are staggering for First Nations, and when you tally this type of water market approach, market value approach, into the actual needs, and compare it with the National Engineering Assessment to bring the water infrastructure up to a standard enjoyed by other Canadians, the cost, is staggering. And First Nations are just going to have, a massive hill to climb, not only with a hill they're already climbing, right? And I could say this too on Bill S8. Just read one of the committee reports some time ago. The concept of Bill S8 is to have these standards for safe, secure drinking water on First Nation. And there's a pile of language in it that transfers liability from the federal government to each First Nation, right? So then if there's no standard, or somebody, let's say, is injured or dies as a result of unsafe drinking water, you no longer look to the federal government, you look to chief and council for relief, right? And band councils don't have pots of money sitting around waiting to be sued. Let's put it that way, okay?
It's $15 million.
That's a lot of money.
That was charged by a licensee when you read the papers.
$15 million was, so somebody already had an existing license, right, with an amount.
They didn't have to pay for that.
And this one, I don't think they did. I think it was an existing, it was the irrigation district that I had this, which was an old license. And they weren't using all of their water, right? So they're allowed, under this new water market strategy, right, to sell a portion of their unused water to someone else who can basically gain entry into the first in time, first in right system. So their $15 million pays for a priority that's really old. So remember in my previous slide where I said there's this voluntary sharing principle where in times of low water, all the license holders are supposed to come together and say, okay, everybody, let's share. I doubt somebody who's invested $15 million for this license will want to share or be as forthcoming to share with people who don't have the money. Just one second. There's an economic upside of the water rights, and these are all controversial. First Nations would not face the debilitating cost of water markets if they had, jurisdiction over their water. Right? First Nation water rights, and this is the economic argument. First Nation water rights and jurisdiction could attract economic investment and development on reserve lands. Rights and jurisdiction will help ensure viability of First Nation communities, traditional land uses, and treaties. First Nation water use is not environmental or management threat. We've heard a little bit about the strong traditional values about water and imposing that in a management system by a First Nation. And rights to quality could be leveraged for adequate funding of First Nation drinking water systems, right? Alberta and BC seem determined to impose this water legislation and markets on First Nations and First Nation lands. Both sides would have to spend a lot of money defending and doing the build-up for the claims and defending against claims for this, to have a third party decide, a judge. First Nations in water-scarce areas will lack security of water supply under water market systems, which will stunt their own development and growth, right? First Nations are determined to secure supply, will face additional costs of purchasing, right? That $15 million, for instance, if they want more water, right? And there's a lot of places in Alberta where reserves are located that don't exactly have a river running right through them or beside them, or have a generous aquifer underneath. If First Nation lose, they're more or less in the same place as if they never had the fight. The problem is it still costs a pile of money to commence any litigation. Your rights are still uncertain until you have them determined finally. In this state right now, things are appealed all the way to the Supreme Court. And that's the end of that. So, I mean, it's kind of a doom and gloom presentation, but it gives you a bit of an idea of the magnitude of issues that are facing First Nations with respect to water in Alberta and BC.